Good morning, Mr. Allen. Mr. Weber, or is it Weber? Weber, good morning, Mr. Weber. You may proceed.
May it please the Court, my name is Robert Weber. I'm an attorney representing Mr. Andrews in this case. This case involves a mentally ill person who was committed to Bridgewater State Hospital by the district court after finding that he was not criminally responsible for the crimes of rape and incest. At the commitment hearing, Bridgewater had to prove beyond a reasonable doubt that the failure to hospitalize him at Bridgewater would result in the likelihood of serious harm by reason of his mental illness, and further that he required the strict security of Bridgewater State Hospital. After he was committed, Mr. Andrews felt he was ready for transfer to a DMH facility, and pursuant to Section 9 of Chapter 123, filed a petition under Section 9b, seeking a new hearing in the Superior Court regarding his need for commitment. At that hearing, he presented evidence of an expert. He overcame a motion for summary judgment and proceeded to trial. His attorney asked the trial court for a ruling that once Mr. Andrews had put in a prima facie case, the burden of proof shifted to the Commonwealth to continue to prove again that Mr. Andrews required commitment beyond a reasonable doubt. The judge
was your client seeking release generally from hospitalization or a transfer to the Department of Mental Health facility?
At that particular hearing, Mr. Andrews was seeking a determination that he no longer required the strict security of Bridgewater State Hospital and that he should be transferred to the Department of Mental Health. Although, Your Honor, I think the legal principle remains the same regardless of whether he was seeking transfer to a less secure facility. Okay. And in fact, I think the principle also applies to patients who are committed to a Department of Mental Health facility under Chapter 123 and are seeking discharge from their facility.
They're all 9B proceedings?
Correct.
Whether it's discharge or to a lesser
exactly.
secure, they're all 9B proceedings.
They're all 9B proceedings, and in point of fact, Your Honor, the statute makes quite clear that the commitment of somebody who is not competent to stand trial, not criminally responsible, or just civilly committable, all follow the same procedures. They all are, before they're committed, they all have to meet this, the hospital has to meet the standards described in Section 7 and 8 of Chapter 123. The only difference in a case involving someone like Mr. Andrews, who was found not guilty by reason of mental illness, is that the court has the additional authority, if they commit him to a Department of Mental Health facility, to restrict him to buildings and grounds. But other than that, it's the same legal standard. The Commonwealth has to prove, or the hospital has to prove in a civil case, that the patient is mentally ill, that the failure to hospitalize will result in a likelihood of serious harm by reason of his mental illness, and they have to prove it beyond a reasonable doubt.
But I thought
that's at the initial
I thought
hearing.
your client concedes all of that. What your client doesn't concede is that he needs to be housed or committed to Bridgewater.
In this case, our client believes that he no longer requires commitment to Bridgewater. That's correct.
So, and that's a separate element that only really applies to Bridgewater commitments.
It only requires to Bridgewater commitments. That's correct. But it applies to Bridgewater commitments regardless of whether they generated from a criminal case as somebody who is not criminally responsible or a civil case. There are patients at Bridgewater State Hospital who no longer have any criminal involvement, who are committed under the civil sections of Chapter 123, and they have the same legal principles apply to them. What we're asking the court today to decide is that once a patient is put in a prima facie case, that the burden shifts to the Commonwealth or to the hospital, that they must prove again that the patient continues to be mentally ill, he continues to require the strict security of Bridgewater, and he continues to present a likelihood of serious harm. And the hospital must...
You haven't addressed this, but I take it that that's the scheme, and I'll ask the Commonwealth to respond as well, that we laid out in Hatch and Elan, correct? Namely, you've got a burden of production going forward, and then you shift, there's the burden of production going forward, and then you shift, the burden of proof shifts back to the Commonwealth, and the Commonwealth has the burden beyond a reasonable
Your
doubt.
Honor, you did it in Hatch, and you also did it in care and protection of Aaron.
That's what I said in Aaron.
Yes. Yes, it's exactly the same procedure, and we believe the reason for that is because the same liberty interests are involved. And this Court has said in many cases, mental health cases, that there's a continuing duty on the hospital, or in this case, Bridgewater State Hospital, to reassess the patient and determine whether or not the grounds for his continued confinement remain.
What does your prima facie case consist?
In Mr. Andrews' case, he had the testimony of Dr. Joss, a forensic psychologist, who had examined him twice, who testified at court and said that in Dr. Joss's opinion, Mr. Andrews' mental illness was under sufficient control that he no longer required the strict security of Bridgewater State Hospital and that he could be maintained and treated safely in a Department of Mental Health facility.
Here the judge in the Superior Court determined that regardless whether the standard were proof beyond a reasonable doubt or preponderance of the evidence, the Commonwealth had met the standard.
That's true.
But the Superior Court judge said it was the plaintiff's burden.
Correct.
Not of going forward.
The
Not correct?
Superior Court judge in this case said that the plaintiff had the burden of going forward and the burden of proof beyond a reasonable
Correct.
doubt.
So I don't quite know what the Superior Court judge did, because if the Superior Court judge says that the plaintiff has the burden of proof of going forward and the burden of establishing a prima facie case and the burden of proof, which is what I think he said.
He did.
You
And
know,
that's-
he hasn't told me anything about what he thinks a prima facie case should be, because he hasn't even looked at a prima facie case.
Well, there was at the close of the Commonwealth's, strike that.
No, there was a JNOV, wasn't there?
Right.
No, there was a.
At the close of Mr. Andrews' case, there was a motion for summary judgment, which was
a
denied.
motion for summary
Which was
judgment.
denied. So presumptively, the judge determined that Dr. Joss's testimony put in a prima facie
But my
case.
point is that the judge is saying it doesn't matter which standard I use. He was using that for the ultimate burden of proof,
Correct.
which he left on your client.
That's right. Mr. Quaglia, who represented Mr. Andrews at the case, asked the judge for ruling on the burden of proof, and the judge made a ruling saying that Mr. Andrews has the burden of proof and has to prove beyond a reasonable doubt that he no longer...
Are these considered civil proceedings?
Yes.
But they still have this reasonable doubt component mixed into them?
All civil commitment cases...
Talk in those terms.
Pardon me?
Talk in those terms.
Yes. The standard that this Court decided some years ago that the standard for commitment, even when the case is brought by the hospital, at the initial case, the hospital must prove beyond a reasonable doubt.
Right. So according to the judge, it reverses 180 degrees when it's the situation you were in. I mean, when he first got sent there, the state had to prove beyond a reasonable doubt. Now, he's got to prove beyond a reasonable doubt that he's
That's
fit
correct.
to get out.
Yeah, and the judge, I think, was relying on Thompson versus Commonwealth.
But it doesn't say anything about the burden, does it?
The Thompson versus Commonwealth simply, in my view, says that the
Plaintiff
has to put in a prima facie case.
Correct.
That's all.
And that's all it says.
So,
That's
in
right.
other words, what we were concerned about is that every time, you know, somebody who's in Bridgewater or whatever, I mean, you may be in a less secure environment and you want to be discharged, you simply say, I want to be re-examined. And we said, no, you have to come forward with something.
Exactly.
Right.
And to go back to Justice Cowen's questions, what I understand the facts in this case, but we're not going to deal just
Right.
with this case. What constitutes a prima facie case, or what would meet the Thompson standard?
Well, it seems to me that what would meet the Thompson standard is any believable evidence that the patient is either no longer mentally ill or no longer requires the strict security of Bridgewater in Mr. Andrews' case.
Well, you'd have to have on almost every case an expert witness.
Absolutely. And that's generally the way we practice in these cases is if we get an expert witness who examines the patient and is willing to testify and is agreeable to testify that the patient no longer meets the standard, then we go forward. Quite frankly, if we don't have an expert witness, we don't have a case.
So you're saying you essentially have to produce evidence that there is a reasonable doubt.
You have to put in a prima facie case.
But what is a prima facie case the equivalent of a reasonable doubt?
I think a prima facie case is sufficient evidence to go forward with the case, whether it raises to the level.
Is it enough evidence? Is it a preponderance of the evidence?
It's enough evidence so that if the Commonwealth said nothing, or the other side said nothing, then
You're not being helpful. Let me put it to you this way. Why doesn't that mean proof beyond a reasonable doubt?
Pardon me?
Why doesn't it mean proof beyond a reasonable doubt? The Commonwealth has just proved a week earlier that he is insane, or he is committable by proof
Well,
beyond
it
a
could have been a
reasonable
week
doubt.
earlier, it could be 5 months earlier.
It could be a week. It could be a day under this scheme. A petitioner could file something the very next day. And I think what we're trying to get at is how much proof is required in the prima facie case. What is the burden?
Seems to me that the burden practically is an expert witness who is willing. It could be the same witness who testified, quite frankly, it could be the same witness who testified at the commitment hearing.
What did we say in Hatch and what did we say in Allen? Because Hatch and Allen both deal with comparable liberty interests, and they both talk in terms of burden of production and then the burden of proof shifting to the Commonwealth. What did we say about the burden of production in Hatch
And in Aaron, you said that the petitioner, the person seeking the court, has to put in sufficient evidence to show that whatever the situation is
But see, the prima facie case, the evidence you put in has got to be linked to the burden of proof. So we've got to establish that. I mean, now take an ordinary civil tort case. The plaintiff has to put in a prima facie case, correct, that would allow a jury to find by a preponderance of the evidence that the defendant was negligent. So we can't avoid that question about what your proof has to show. It would have to be enough to warrant a finding by the fact finder, either beyond a reasonable doubt, preponderance, whatever it's going to be.
Well, taking the reasoning of the court in Thompson.
Well, Thompson, there was no evidence.
No, but what Thompson did say was that because it was a civil matter and because it was a civil matter the petitioner in any civil matter had the obligation of putting in a prima facie case. It seems to me if you follow that logic, then the petitioner has to put sufficient of a case to show by a preponderance of the evidence.
The amicus, without addressing this specifically, says substantial evidence. You're saying sufficient evidence. And I'm reading from the amicus brief, putting the burden of coming forward on the Commonwealth, but its decision is not disposed, indeed is not even instructive on the burden. Unlike the petitioner here produced substantial evidence, and you're saying you have
I would argue that, following the logic of Thompson, that the petitioner has to put in sufficient evidence that
But he's not mentally ill or that he's
not committable.
He can be put in a controlled
Right,
environment or
by a
whatever.
fair preponderance
But that's
of the
got to be
evidence.
linked to some burden of proof.
And I would suggest that, following the logic of Thompson, that burden of proof would be by a fair preponderance of the evidence.
And then all of a sudden it switches to
Then
a
all of it
reasonable
switches.
doubt on the other side?
Absolutely. And
Thompson doesn't say any of that, does
Pardon me?
Hatch and Allen do.
Hatch and Aaron say that?
Yes.
No, well, I'm not exactly familiar with the standard in Hatch. What Aaron said was that the standard the Department of Social Services then must prove by clear and convincing evidence that the child continues to remain in need of care and protection. And the reason for that was because that's the legal standard that the Department had to meet at the initial case.
But didn't the judge say here that regardless of whether you use beyond a reasonable doubt or preponderance, the petitioner didn't meet either standard?
In this case, that's what the judge decided.
Because the judge was putting the burden on the petitioner.
That's correct.
Not on the burden of production, on the burden of proof.
He's putting the burden of proof on the petitioner.
So you argue that the judge made two errors. One, putting the burden of ultimate proof onto the petitioner.
I argue the judge made two errors. The first is, if he put the ultimate burden of proof on the petitioner, it should be by a preponderance of the evidence, not beyond a reasonable doubt. But secondly, and more fundamentally, my argument is that the burden should have shifted to the Commonwealth.
Correct.
And if I can just very briefly, Your Honor, the Commonwealth in its brief argues that the reason the burden should not shift is because of the additional cost and
I
expense.
understand.
Did Hatch...
And that's a bogus argument, quite frankly, because Thompson addresses that. Once the prima facie case has been put in, the Commonwealth puts in the same case it would put in if they have the burden of proof or if they didn't have the burden.
Did Hatch and Aaron both involve burden shifting within a single proceeding, or were they independent proceedings, as we have in this case?
Aaron was an independent proceeding, very similar to this case, where the parent filed a request for I think they call it a reconsideration or redetermination, which is essentially identical.
Within the 1 year or within the commitment?
Yes.
They had a right to do that annually. That's
Yeah.
correct.
If we agreed with you in this case, what would be the remedy?
Well, for Mr. Andrews, he's been recommitted a couple of times. There would be no remedy for him. It's somewhat moot as to him. The remedy would be that the court would order that in future 9B proceedings, once the petitioner puts in a prima facie case, the burden shifts to the hospital or to the Commonwealth in the case of
I think we
Bridgewater.
recognize that the
Yeah.
cases to this petition is moot, correct?
Yeah.
I mean, I'll ask the Commonwealth
Right.
that as well. Yeah. Thank you, Mr.
Thank you, Your Honor.
Levin. Mr. Rabbits, you're doing 10 minutes?
Yes, thank you.
Why don't you, for the record, explain who you are, and then I'll ask my first question.
Randall Ravitz on behalf of the Bridgewater State Hospital.
Thank you. Mr. Ravitz, and maybe you can just help me explain a very fundamental thing. This petitioner was recommitted.
That's right.
Why? I mean, what triggers a recommitment?
Well, certain...
This is under Section 3, is it?
Under 16,
So,
or 7 and 8. Or
Well, 16 discusses commitment for those found not guilty by reason of mental illness generally, and it refers to both 7 and 8, which deal with all situations. He was committed, and at that proceeding, it was found beyond a reasonable doubt, based on the Commonwealth's burden, that the statutory criteria were met, and then he was recommitted.
but I'm trying to understand, why was he recommitted? In other words, what triggers a recommitment? There's probably a simple answer, and I just don't know it.
The head of the institution...
Well, no, there's a statutory right to recommitment, isn't there? You're committed under Section 16 for a period of 6 months, and then every year after that, the institution has to repetition by statute. Is that right?
That's right. The head of the institution...
And that happened here.
Yes.
Okay, so it's the annual, it's an automatic annual review.
Yeah.
Okay, thank you.
That's right. Just to put Thompson in its proper light, Thompson did not state, and Thompson clearly governs here, and it did not state that there's simply a burden of production upon the petitioner in a 9B proceeding. It stated that the burden of proof or the burden of persuasion is on the petitioner. And that's clear from both from the language and the briefing of the Thompson opinion. It repeatedly used the term burden of proof. That term has been equated with burden of persuasion in other opinions by this court. An example is one of the Demoulas cases, and I'm sorry, I don't have a citation. In addition, the briefs by both parties recognize a distinction between the terms burden of production and burden of persuasion, and they equated burden of proof with burden of persuasion.
So in this case, it's not simply introducing enough evidence that would create a reasonable doubt.
That's right. That's right.
Okay.
And in fact, it also wouldn't be a proper reading of Thompson to state that it allows for a burden shifting, because if the petitioner just had to prove a prima facie case, he would just have to prove his case at the close of his case in chief, whereas what Thompson calls for is proof at the close of all evidence. That's what's meant by the burden of proof. And in fact, statements in Thompson really wouldn't make sense if the court had been...
Wait a minute. So you're saying that, let's say just hypothetically, we say that the burden of proof is on a petitioner to establish that he is not committable by a preponderance of the evidence. Okay? You're saying that then that the burden, that the Commonwealth does not have the opportunity to prove beyond a reasonable doubt that he is committable? Because isn't that the import of what you're saying? If he meets his burden of proof.
No, what I'm saying is that when we talk about what his burden of proof is, we mean at the close of all evidence, not just at the end of his case in chief.
But Thompson was a summary judgment.
That's right. That's right. But the
And in Thompson, I mean, it's a little confusing because in Thompson there was he came forward with nothing. And the issue was, had summary judgment properly entered against him?
right, right. But the
So Thompson doesn't even look at the situation that you have here, which is where the petitioner comes in with something. I know you say, look, it couldn't mean, but the facts frame what the legal issue is.
yeah, but at the same time, the court went beyond the facts there, and that's reasonable to think that was its intent. It would be unreasonable to conclude that the court was presented with this issue and resolved it in such a way that would still leave the question open for future proceedings. And in fact, some of the discussion in Thompson wouldn't make sense if the court had been talking just about a burden of production. For example, it said that it recognized that there was a risk that somebody could be erroneously retained in confinement. That wouldn't make sense if it was just talking about the allocation of the burden of production. It makes more sense if it's talking about the allocation of the burden of persuasion.
Why?
Because
I mean, consistent with Allen and Hatch and all of our jurisprudence, in essence, and to some extent that's consistent with what I now understand as a one-year review, is there are profound liberty interests, not only in being incarcerated, but the level of incarceration, the degree of security, and so on and so forth. And that burden, I think, always rests with the Commonwealth. The question is, what's going to trigger a review other than the annual review? I mean, it's a little hard for me to see.
what's going to trigger a 9B proceeding?
Yes, that is to say, you don't take the burden off the Commonwealth.
Well, what will trigger it is some proof by the petitioner that would
Correct.
warrant a finding. We have yet to determine the standard, we'll say beyond a reasonable doubt, that he should be released.
Right. Well, let's look at it this way. In any case where a petitioner presents a 9B petition, it will always be the case that he was just recently proven by the highest standard we have, beyond a reasonable doubt, to require strict security and that the other statutory conditions were met. And so that this proceeding is something different. It's something special. It's a challenge. It's essentially a challenge to a ruling that was just made or an argument that things have changed very quickly.
I don't accept that only because of the language that we consider. I mean, you may think of it as only a year. We don't think of it as, I mean, not we individuals, but the law doesn't recognize it as only a year. And the question, I suppose, I mean, as a practical matter, Mr. Lavitz, how fast does a 9B hearing get scheduled and determined?
Well, first, if I could just say that the Thompson court did explicitly state that the length of time that we would be dealing with in a 9B situation is temporally short and does not rise to the level of being a substantial infringement on liberty. They recognize that in the longest situation it would be a year, but in practicality it would always be, or it would generally be much less than that, because first, people just don't heal that quickly, but also it takes a certain amount of time to go through the proceedings, and that brings me to your question.
As I understand your argument, and correct me if I'm wrong, but Hatch and Aaron would not be relevant because Thompson has already crossed that bridge and said, look, this is not a case where we get into this burden-shifting stuff. The burden is on the petitioner all the way.
That's exactly right. And that's the way it's been applied.
So analogizing this situation to those cases is really a red herring.
That's right. Chief Justice Marshall, I think that it varies from case to case. In this case, the petition was filed 5 days after a recommitment proceeding, and I believe that the hearing at issue took place 4 months before the next recommitment hearing.
So essentially 8 months.
That was, in this case, I believe that was the situation. And it's reasonable to put that burden on the petitioner, because, as I said, in all cases, it will have been proven recently beyond a reasonable doubt, which is a standard that is higher than what's constitutionally required, that the petitioner belongs in strict security.
What I guess I'm having a hard time understanding is, since the Commonwealth had just proven beyond a reasonable doubt that he should be committed, right, because there had just been a commitment hearing. So why can't you just put in, say, the same evidence or even the record of the same evidence?
Well, essentially,
what's changed do you consider it when you have the hearing 8 months later? Is the consideration as of 8 days at the time it was filed, or as of the 8 months later?
It's really as of the 8 months later, but that's why the Commonwealth is really in the worst possible position, because the petitioner will have to argue that something has changed.
Changed in the 8 months.
Right. So the Commonwealth can't just submit the same report. But at the same time, it's unlikely that the situation really has changed, as the Thompson Court recognized. So the Commonwealth will have to go through this burden, where in many cases it'll really be inappropriate. And that's why we have proceedings every year. We have proceedings every year to guarantee a level of protection of the petitioner's liberty interest that, as I said, is higher than what's constitutionally required. And then on top of that, we have yet another protection. And they get the benefit, they get appointed counsel if they need it, they can get an expert if they need it.
Mr. Levitz, can I ask you this? Whatever we decide about the burden of production, what would be the impediment to saying that when the petition is filed on a 9B, the petitioner at that stage, like a summary judgment motion, has to lay out what in other words, if there's an expert report, the expert report has to be filed at that time, correct?
Right.
Because the Commonwealth has put in, as you say, this anomalous situation that it's filed 5 days later or 2 days later or a week later, and then because of the clunkety-clunk, clunk, 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 it may take 8 months, and then the argument is whatever you put in at the commitment proceeding is no longer valid, correct? When was the expert's report put in this case?
That, I'm sorry, I don't recall.
Do you know whether it was put in at the time that the petition was filed?
Well, I know that there were evaluations shortly before the hearing itself.
No, not the hearing. Filing of the petition.
Well, correct. He shouldn't be able to file unless he's got an expert
Well,
witness.
that's my point.
In other words, there are evaluations done between the filing of the petition and the hearing.
Why could we not say you have a petition and you file it with whatever you have? In other words, you don't file your motion for summary judgment, then take all your depositions, and then decide whether you've got enough for motion for summary judgment.
That would delay the filing of the petition.
That's okay.
Not only that, but I take it the filing of the petition triggers the right to counsel, the right to expert, so that is all triggered by the filing of a petition. It would be a little difficult to have the petition fully born before it was even birthed.
That's right.
Thank you, Mr. Levitz.
Thank you.
Ms. Lord-Lytton?
Good morning. May it please the Court, my name is Donna Reardon. I'm here on behalf of the Plymouth County District Attorney's Office. If I might, listening to the concerns of the Court, perhaps call to the Court's attention that with respect to these 16C recommitments, it's not actually a review. The commitment the initial commitment, 16B, actually expires at the conclusion of the 6 months. the hospital has to then file a petition for recommitment. At the conclusion of the year, that commitment expires. It's done with, and the hospital again files a petition.
And that's why this is different than Aaron and Hatch.
Exactly, because in Aaron, that was the determination by the court that that juvenile could not live with her mother. She belonged in DSS custody. Now, there was nothing to say in a year that order expires, in 6 months that order expires. That was an order that would remain in effect.
But does that statute also use the word review?
It's a review and a redetermination under Aaron.
Okay.
Under Aaron.
Now, under
And
Section 9, do they use the word
they
review?
say application.
Okay.
That's how the statute reads under 9B, an application. And what I would suggest to the court that under Section 16, the Commonwealth does have the burden. We have the burden to go forward. We have the burden to prove beyond a reasonable doubt that a patient, in fact, meets the commitment criteria, and that is met 6 months initially and on a yearly basis. In addition to that, if you look at Section 16E, and a copy of that is contained in the petitioner's brief, what that section indicates is that during the period of commitment, that I would suggest it says the hospital, Bridgewater State Hospital, or a DMH facility has a continuing duty to make sure a patient meets the commitment criteria. And if during that time period they feel a patient should no longer be committed, then according to that section of the statute, what they have to do is notify the district attorney's office, and once the district attorney's office is notified, they have 30 days, a set time period, to decide whether or not they want to file their own petition. So in addition to having a specified term of commitment, the hospital also has, during that time period, a continuing duty to make sure that patient meets the commitment criteria.
Does that in fact happen?
Yes, I'll tell you, I handle mental health cases on behalf of the DA's office, and it is not uncommon for me to receive notice from typically a DMH facility that they want to discharge a person, and I have 30 days to make a determination whether it is appropriate for me to file a petition on behalf of.
And what about between Bridgewater and DMH?
That Section 16E also addresses that. If you note in the statute, it says that if there's restrictions placed on a person during their commitment period, and the hospital, the facility, no longer feels that those restrictions are appropriate, then they have to notify the court, and if there's no objection to reducing those restrictions, then those restrictions are.
So what's the answer to this case, in your opinion?
I would suggest to the court that given the protections that are already in effect, that the 9B, as my brother pointed out, is just sort of another added safeguard. But what should happen is, as the Thompson case, I would suggest, states, that the burden should in fact be on the petitioner, that he or she should no longer be committed to a hospital or no longer requires the strict security of Bridgewater, and the patient or petitioner should have to prove that beyond a reasonable doubt.
Ms. Laird, may I ask you this? As I looked at 9B, one of the things, for whatever reason that section was in there, and you know, we've received some statutes of history on that, one of the things that seems to be clear is that what the legislature contemplated was a very fast determination.
Under 9B.
Under 9B.
Yes.
In other words, they did not contemplate what Mr. Lavitz has essentially said is almost the same time period. In other words, that you have a commitment, and then a year later you have another commitment, and here you have 7 days and then essentially 8 months. And so what the Commonwealth is doing, preparing for the 12-month review, is not substantially different from the 8-month review. I mean, they talk in terms of, you know, it's a written application within 7 days. I mean, it's a very expedited proceeding, correct?
Yes, but I think, you know, it depends. You look at this case, for example, Mr. Andrews. His commitment hearing happened on March 3rd of 2004. Yes, he filed this 9B petition, But then what happened? On September 1st of 2004, we were back before the court
But
again.
that's what I'm saying, but that seems to me not what's contemplated by 9B, because 9B talks about a 7-day hearing.
But that's, I mean, I think practically speaking, oftentimes what happens is these 9B application will be filed, and attorney for the patient, for whatever reason, doesn't want to move on that.
Well,
You know,
then
and-
they're not entitled to that.
I'm sorry.
Well, probably they're spending that time having the
Yeah, but
expert
that's
examine
exactly
and
what
getting.
that's not what 9B contemplates.
Well, it contemplates the appointment of counsel at the time that the petition's filed, and then the person presumably is brought into court and counsel's appointed if they're indigent.
Yes.
So that all suggests, and we're talking about expert evidence here, so
Correct.
it all suggests that this isn't going to happen in 7 days or 14 days or 30 days, at least in accord with the standards that we now require for such things.
And it's probably not going to happen very quickly, because if the petitioner had that type of evidence available, he would have used it at the original commitment hearing.
recommitment.
Well, ironically, in this case, that same expert did in fact testify at the commitment hearing.
But he has to have something on which to base some change, since it wasn't enough
Correct.
to convince the fact finder originally. There's got to be some change, so you've got to have some period of time, it seems.
Well,
Correct. And
I'm not so sure.
well, I think when you look at the statute in its totality, that there are, in fact, enough protections there already to make sure that, you know, a patient is not there when he shouldn't be, given the fact that it does come up yearly, and given the fact that, and I think this is a critical point, that it's for a definite period of time. In addition to that, once a petition for commitment or for recommitment is filed, if you look at the statute, the hearing for that petition has to be held within 14 days. And only the patient or his counsel can continue that. So I think that the legislator took...
Which hearing is that?
The
Under
recommitment.
16.
Yeah.
Under 16.
Correct.
Yes.
Or actually, any 7 and 8, any commitment under Chapter 123.
And the Commonwealth does that, correct?
Yes.
Yes, and so it seems to me, you know, notwithstanding the comments about you have a right to counsel, you've got a right to everything else, if you can't get your act together within a very short period of time, if you're a petitioner, you're out of luck. In other words, you can't, the Commonwealth can't, in a recommitment, take a year or 8 months, let's say 8 months, can't take it 8 months to get its expert and so on and so forth.
Well, but the Commonwealth, I take it, of course, the Commonwealth has custody of the individual and is evaluating the individual on a regular basis. So when these recommitment hearings come up, I assume they're ready to go.
Yes.
And the real issue is the petitioner or the patient getting ready to go.
Are you talking about a 16?
I'm talking about a 16 or after
No,
their
9B.
No. Well, let's unpack this a little bit. 16 is the original commitment. That's 6 months.
Right.
And then they can be committed for yearly periods.
Correct. Under 16C.
Is that under 16 or under 7, 8, and 8?
That's under 16C. If there's a criminal, if a person's been found not competent.
So all
or
of the
not-
commitments are under 16 if they've been found.
Not competent or
or
not
gui-
guilty by reason of insanity.
So all of these yearly commitments are under 16.
As with the case with Mr. Andrews,
All
yes.
right. Now, presumably, the Commonwealth comes into this 16 recommitment hearing ready to go because they've, of course, had the person for a year.
Yes.
They've been evaluating him on a regular basis. They sort of know what the evidence is, right?
Correct.
What does the petitioner get to do in connection with those hearings?
The petitioner can, or the patient,
Patient,
in the
excuse
16 hearings can, obviously they're appointed counsel, they can file a motion for funds if they want to retain their own expert to evaluate them and make a determination regarding their committability. Since pursuant to the statute, they can continue the case, they can request that the commitment hearing be continued until that's done, and then they will bring their expert in. At the conclusion of the hospital or DMH's case in the commitment hearing, they would have an opportunity to call their expert, to testify if they want to call any witnesses that they want to at that commitment hearing.
What's wrong with saying that the petitioner has a burden of proof of a preponderance of the evidence? What's wrong with saying that, as opposed to beyond a reasonable doubt?
In a 9B hearing,
Yeah.
you're suggesting. I would state to the court that, given that, first of all, that under the statute, the Commonwealth has to prove beyond a reasonable doubt that
And
the person...
to defeat that, the petitioner only would have had to have shown a reasonable doubt at the what is it, the Section 8 hearing. Now the petitioner has a greater burden. He has to prove by a preponderance of the evidence that he's not committable.
Well, I think, so you're suggesting that put the burden on the petitioner, but make him only have to show by a preponderance.
What's wrong with that? Is there anything wrong with that as opposed to making the petitioner prove beyond a reasonable doubt that he's not committable?
I think given that, and when you look at the mental health committee, the work and time and effort that they took into generating this statute, Chapter 123, they took into consideration that you need to look at the loss of liberty of the patient. You also need to look at the potential harm to the public that if someone who is mentally ill and could be a danger is discharged into the community. And I think that
But the preponderance evidence puts a greater burden on a petitioner than he would have had at a commitment hearing. At a commitment hearing, in order to walk the streets, all he had to show was a reasonable doubt. Now he's got to prove by a preponderance of the evidence that he's not committable.
He's moving from a negative to a positive.
I understand, but I think that positive should be, he should have to show beyond a reasonable doubt that he can be
I'm frankly
discharged.
less concerned about that than whether or not it's a preponderance or reasonable doubt, and I understand, we'd have to look at this, but that it can't be that you've got these 1-year reviews and that we're putting, essentially running two parallel proceedings because the 1 year comes up and this is taking place over 8 months. Even if you have a preponderance of the evidence, he's got to come up with something other than his signing a petition, correct?
Correct.
Yes.
Isn't this in some ways analogous to the delay before trial? Supposedly, when the Commonwealth indicts, it's ready to go to trial, or it could be go to trial. And then the 6 months or 9 months that passes is really for the defendant to get the information and to get its witnesses together for trial. And the same thing here. The delay between the filing of the petition under Section 9 and the hearing is really for the defendant to get the evidence that he needs.
Well, I think that these petitions are filed by the Commonwealth. And
the 16.
The 16s, the 7 and 8,
Right.
correct.
They have
the
to be.
9, right. I think the 9B, as my brother pointed out, is that's the patient saying, coming forward and saying, you know what, something's changed, I no longer need to be committed, and it's, as he stated, sort of a challenge to that commitment finding. So it's not really a...
If you had the hearing the next week, it would be in the nature of a motion for new trial or a motion for reconsideration because the decision has just been made a week earlier. So how can anything have changed in a week? Say you went before the same judge a week later. The same judge is going to say, listen, I just heard this a week before, and I found beyond a reasonable doubt he needs commitment and secure facility at Bridgewater. How can you say to him, what has changed in the week?
I agree with you, and I think that's why in these 9B hearings, if the patient feels that something has changed, they should have the burden at the hearing to prove beyond a reasonable doubt that...
Thompson already says they have the burden.
Right.
So the only question is, what should it be? I think we're overcomplicating this immensely, as I see it.
And with that, Ms. Leardon, your time is up.
Thank you.